Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service helping thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have an extraordinary person and an attorney, Kevin Estevez, who represents Arizona business owners, contractors, subcontractors, construction suppliers. He also is a prolific and great writer. He writes a blog called Arizona Construction and the Law. Above that all, he's a father of two and a great husband. And today we're going to have a very, very helpful webinar on Arizona preliminary 20-day notices, lien and bond claim refresher with pro tips. But before we get started, I would like to make one little note to all the listeners. You never really know what people are going through in life. So today, if someone doesn't have a smile on their face and they have a frown, don't be afraid. As long as they're vaccinated, of course, these times are crazy, to give someone a hug. So with that being said, I give the mic to Kevin.
Ariella, thank you very much for that wonderful introduction. Like Ariella said, my name is Kevin Estevez, and I'm a partner at Holden Willits in Phoenix, Arizona. And we're a law firm that is advocates for those in and those affected by the construction industry. And I'm going to talk a little bit today about Arizona preliminary 20-day notices and lien and bond claims. So with that, let's jump right in. Contractors and materials suppliers who furnish labor and or materials to Arizona construction projects have various remedies available to them in the event of non-payment. Without question, two of the most effective remedies are mechanics liens and payment bond claims. And I'm going to talk about both in detail in a few minutes and talk about the situations where each apply, because with mechanics liens and payment bond claims, they are mutually exclusive. You're not going to have a situation where both apply. But first, I'd like to talk a little bit about probably the single most important early step that a contractor or a supplier can take to ensure payments on a construction project. And that is to serve a preliminary 20-day notice. Preliminary 20-day notices in Arizona go by many names. Some folks call them pre-liens, some call them prelims, some call them 20-day notices. But however you refer to them in common parlance, the most important thing to remember is that they are absolutely critical. And why are they so important? They're so important because in most situations, contractors and suppliers must timely serve a proper preliminary 20-day notice to preserve either mechanics liens or payment bond claims. They are the key that opens the door to the world of mechanics liens and payment bond claims. So if you take one thing away from this talk today, it should be that. Get in the habit of timely serving adequate preliminary 20-day notices at the outset of the construction projects that your companies are working on. And that is my pro tip number one for the day. I said a second ago that in most situations, contractors and suppliers must timely serve 20-day notices. With respect to lien claimants, with the exception of laborers for wages, every lien claimant in Arizona must serve a preliminary 20-day notice to have lien rights on a project. And some Little Miller Act bond claimants also must serve preliminary 20-day notices to preserve their bond claims. If you don't serve a 20-day notice at all, and it's in one of the circumstances that I just described where you need to serve one, you'll forfeit all lien rights and you'll forfeit your bond claims on the project. If you don't serve a timely 20-day notice in those situations, you forfeit a portion of your lien rights or bond claims. And we'll talk about the situations in a little bit. It's best practice to serve a 20-day notice at the outset of beginning work or furnishing materials to a project. You don't have to, but if you serve it late, you're going to give up a portion of your lien or bond claim. The idea behind preliminary 20-day notices is to give the owner advanced information of the identities of any unpaid claimants who may perfect lien rights against the property if their debts remain unsatisfied. In short, they let the owners on the project know who is working on the project and who's expecting to get paid. So with that, let's talk a little bit about the contents of preliminary 20-day notices. Pursuant to ARS 33-992-01, 20-day notices must contain the following information. First, a description of the labor or material that will be furnished and an estimate of the total price thereof. And that's an important one, and we'll get back to that in a second. 2, the name and address of the person furnishing the labor and materials. 3, the name of the person who contracted for the purchase of the labor and materials. 4, an adequate description of the job site for identification. And 5, a specific statutory notice prescribed by ARS 33-992-01C5. And you can look that notice up in the statute, but basically what it does is advises the owner that the preliminary notice is not a lien, that it advises the owner of the effects of non-payment, and it advises the owner of the steps it can take to protect the property from liens. So that's what's required in a 20-day notice. ARS 33-992-01 includes a sample of a preliminary 20-day notice, and it's a good reference point in preparing notices and making sure your notices are correct, to refer back to what's in the statute, because as a matter of law, claimants are obligated to substantially follow the statutory form. So you can go to the Arizona legislature's website, pull up 33-992-01 and see what a preliminary 20-day notice should look like and what it should contain. I talked a second ago about the estimate of the total price, and I noted that this is a particularly important component of a preliminary 20-day notice. And that's because a lien claimant or a bond claimant is limited to 130% of the estimated amount in the 20-day notice. That means that if you have a estimate your preliminary 20-day notice that the value of the labor or materials that you're going to furnish to a project is $100,000, you have lien rights up to $130,000. So there's a little wiggle room built in within the statutes to account for changes and increases to contract prices that may occur during construction. If, however, the amount of the labor and materials furnished to the project increases beyond this 130% threshold, the preliminary 20-day notice should be supplemented. And it should be supplemented right away, but no event later than 20 days, within 20 days of furnishing the additional labor or materials. And my second pro tip of the day relates to the supplementation of preliminary 20-day notices. And the supplemental notice must set forth the new estimated total price of labor and materials furnished to the project. And it shouldn't include a piecemeal supplementation. What I mean by that is sometimes if you have an original contract that's $100,000 and there is a change order for $50,000 that would put you over the 130% threshold, you'll see supplemental notices being sent out that just include an estimated total price of $50,000. So they're capturing the amount of the change work. And that is technically incorrect as a matter of statute. The way that the preliminary 20-day notice, the supplementation, should read would be that the estimated total price for the labor and materials furnished is $150,000. So you want to have that estimated total price be the full amount, including the change order, of the labor and materials that are going to be furnished to the project. So I've identified a number of things that must go into preliminary 20-day notices and things to be on the lookout for when you are having those completed at the outset of a project, hopefully. But what if you don't have the requisite information? Well, the statute recognizes this, and it provides that if you don't have the information you need to properly complete a 20-day notice, as a potential lien or bond claimant, you can request the necessary information in writing from the owner. And the owner and or other interested parties are required to provide the necessary information to you as a lien claimant within 10 days of your request. Also, upon receipt of a 20-day notice, owners or other interested parties have 10 days to furnish information to correct any inaccuracies. Failure to correct inaccurate information prohibits the use of those inaccuracies later on down the road by owners or other interested parties to invalidate lien claims. So unless the owner or the other interested party speaks up, they will be unable to use inaccuracies or perceived inaccuracies in a 20-day notice to invalidate a lien or bond claim later on. So we've talked about what needs to go into a preliminary 20-day notice, and let's talk now about service of those preliminary 20-day notices. They must be served on the owner or reputed owner of the project, the original contractor or the reputed contractor on the project, the construction lender, and the person with whom the claimant contracted. So those are the folks that need to receive a copy of your 20-day notice when it's sent out. And they should be addressed to the recipients at their residence or business address and served via two methods. Number one, first class mail with a certificate of mailing, which is the most common method. Or two, registered or certified mail with postage prepaid. And preliminary 20-day notices are deemed served when they're deposited in the mail. That is the old legal concept of the mailbox rule, that once it's put in the mail, it's deemed served. Now, when to serve 20-day notices? As I said at the outset of this webinar, it's best to serve them at the beginning of work on a project. And that's because preliminary 20-day notices have that name because they catch back 20 days. So they reaches back 20 days. So if you serve a 20-day notice at the outset of work on a project, or anytime within the first 20 days of work being performed on a project, it'll reach back to the beginning of when work was performed, and it'll cover going forward, assuming the amounts are correct, all the labor and materials furnished on the project. Preliminary 20-day notices can be served after 20 days of when work commences or materials are furnished to the project. But in that situation, as I mentioned at the outset, you're going to lose lien rights or a bond claim for the portion of the work or materials that were furnished in the time frame before you serve the 20-day notice. And a simple example of this is if you have a subcontractor who furnishes labor materials to a project beginning on May 1st, and they don't serve a 20-day notice until May 30th, that notice will catch back 20 days, so it'll reach back to May 10th, and the lien claimant will have lien rights or a bond claim for the materials or labor furnished from May 10th going forward. So that first chunk of time is not going to be covered, and the lien claimant won't have rights for those labor and materials. And so, as you can imagine, as you're moving down on a construction project, and the longer you wait, the bigger gap you're going to have in your lien or bond claim coverage. So that's why it's important at the outset of construction projects to get preliminary 20-day notices served from the jump. So provided that a lien claimant, bond claimant, in a situation where it's required, serves an operative 20-day notice and has not otherwise waived lien rights, it will have the ability to record a mechanics lien. And mechanics liens assert an ownership interest in real estate on the grounds that the claimant provided service or materials to improve their property, but has not been paid. And if you think about it, this is a special protection that is furnished to those in the construction industry on the recognition that essentially you folks provide credit to get construction projects off the ground. For the first, until your first payment, you're working and providing materials on the promises that you're going to be paid, and that's how jobs get off the ground and get working. So the law recognizes that and says that because those in the industry are sticking their necks out and extending this credit, they should be protected with security interests in the project for the work and the materials that they furnish. So mechanics lien statutes are intended to balance the playing field by giving those who provide labor, materials, and equipment to improve an owner's property security for the payment that's due. Arizona lien statutes are remedial and are to be liberally construed to affect their primary purpose of protecting laborers and materialmen. And that is consistent with what I just said about that statutory purpose of protecting those who are extending credit to get construction projects going. That said, strict adherence to the applicable statutory deadlines, which are both complex and numerous, are necessary to perfect a mechanics lien. In order to secure a mechanics lien on a project, aside from serving the preliminary 20-day notice, which I said earlier is a precondition to any lien rights in Arizona, an Arizona lien claimant must timely record a notice and claim of lien within the county where the work is being performed, and to serve a copy of that notice and claim of lien on the owner within a reasonable time. Now, I just mentioned that Arizona lien statutes are remedial and are to be liberally construed to protect those providing labor and materials to projects, but that doesn't mean that all contractors have lien rights. And pursuant to Arizona law, there are certain exceptions to mechanics lien claims. The first, and I sort of touched on this at the outset, is you can't have liens on public property. And in those situations, payment bonds are substituted for lien rights, and we'll talk about payment bonds in a few moments. But if you're working on a public project, just know in most circumstances you're not going to have lien rights. The second exception in Arizona is owner-occupied residences, and they can't be liened unless the contractor or supplier has a direct contract with the owner. And this is one that catches folks off guard on a regular basis. And in short, it means that if you are a subcontractor performing residential work, unless you have an agreement directly with the owner, you don't have lien rights. A third and more complicated exception is in the case of tenant improvements. If you're doing TI work and know that you may not have lien rights against the entire property, you may only have lien rights against the tenant who you're performing work for's leasehold interest in the property, and that gets fairly complicated in terms of ascertaining whether a contractor has lien rights against the entire project or the leasehold interest. But just bear that in mind, that if you're doing that type of work, you may not have lien rights for the entire scope of work. Also, it is important to remember that purchase money and construction loans, in most instances, will have priority over a mechanics lien. Not all instances, but in most cases, that will be the case. So lien claimants will fall in behind construction lenders in most situations. Lastly, if a contractor is required to be licensed to perform work, and the contractor doesn't have a license, that contractor will not have mechanics lien rights. So mechanics liens, the notice and claim of lien, as I talked about, in order to perfect the lien, must be recorded with the county recorder in the project, in the county where the project is located, and this must be done in a timely fashion. And the rule is it must be done within 30 days it must be done within 120 days after project completion. Pursuant to ARS 33993C, completion, and this is probably the most common definition of completion. It occurs 30 days after a certificate of occupancy is issued. So in that circumstance, if a certificate of occupancy is issued on a project, as a lien claimant, you will have 150 days. So you have the 30 days, because completion is not defined until 30 days lapse after the certificate of occupancy is issued. And then you have the additional 120 days provided by the statute to record your lien. If no certificate of occupancy will be issued, if that's the type of work that's being performed, and no C of O will be issued, completion occurs on the last day when labor or materials are furnished. So in that circumstance, you'll have 120 days. If completion occurs, if the work is stopped or the work is abandoned for 60 days, then completion will have been said to have occurred 60 days after the work's abandoned or the work is stopped. So in that circumstance, you'll have 180 days to record your notice and claim of lien. And the last circumstance, and this is an outlier, is if the owner records a notice of completion. And a notice of completion, as you'll see here on the slide, it must be recorded and it must be served on those who furnish preliminary 20-day notices on the project by the owner. And what that notice of completion does, pursuant to Arizona law, is it accelerates the deadline for lien claimants to record their liens. And it bumps that deadline up to 60 days after the notice is required. So unless you are working on a project where the owner furnishes a notice of completion, and you need to be, and you will be alerted to that by virtue of the fact that if you serve a 20-day notice, you should get a copy of that notice of completion served upon you. So setting that circumstance aside, it's pro tip number 3 today is to calendar 120 days after you last furnish labor or materials to a project as your deadline to record record your lien, and recognizing that in most circumstances that is going to be early, because one thing we'll see here with mechanics liens, and it's different than payment bond claims, is the deadline to record a lien is from project completion. And so if you think about that, there can be quite a disparity in time depending on what type of materials you furnish, what type of labor you provide to a project. I mean, the folks doing the excavating work on the project are going to be out there early, whereas the folks doing painting work on the project will presumably be out there late. But in either case, the deadline to record a mechanics lien is 120 days after completion of the entire project. So You will have a disparity depending on the type of work you do in when you have to and how long you have to record your lien. But a safe rule of thumb is 120 days after you last furnished labor or materials to the project. So we talked a little bit earlier about the contents of preliminary 20-day notices. I'll now touch briefly on what's required to be in a notice and claim of lien. And this can be found in 33-993A of the Arizona Revised Statutes. And the first thing that's required to be included is the legal description of the land and the improvements to be charged with the lien. That's number one. Number two is the name of the owner or reputed owner of the property concerned, if known, and the name of the person by whom the liener was employed or to whom he furnished materials. That's number two. Three, a statement of the terms, time given, and conditions of the contract if it is oral, or a copy of the contract if it is written. That's number three. Four, a statement of the liener's demand after deducting just credits and offsets. That's number four. Five, a statement of the date of completion of the building, structure, or improvement, or any alteration or repair of such building, structure, or improvement. That is number five. And six, a statement of the date the preliminary 20-day notice required by ARS 33-992-01 was given. So that's what's required to be in a notice of claim of lien, which must be recorded within 120 days of completion on the project. Once you record your notice and claim of lien, you then have 6 months to sue to foreclose. If no suit is filed within that 6 months, the lien expires by operation of law. So pro tip number 4 here is the difference between the deadline for knowing when to record a notice and claim a lien and the deadline to sue to foreclose. The deadline in terms of recording the notice and claim a lien is calculated in terms of days. You have 100, you have from 60 up to 180 days to record the notice, but you have 6 months to sue to foreclose, and that distinction between days and months in these two instances can be meaningful. What the foreclosure sale does is ask the court to order the sale of the property to satisfy the lien. Claimants with valid mechanics liens share the proceeds of the sale pro rata, but each lien claimant is required to prove the validity of his or her lien and the reasonable value of the materials or services he or she provided. So that is a brief overview of mechanics liens. I'll now conclude today's webinar with briefly touching on public project payment bond claims. And as I said in talking about liens, you don't have lien rights on private projects because, I'm sorry, on public projects. You don't have lien rights on public projects. You only have lien rights on private projects, and that's because public property cannot be liened. And because the public property can't be liened, in most instances, federal and state law require payment bonds on projects of a certain type and size. Qualified subcontractors and material men may have claims against the bond if they satisfy the notice requirements. So under the Federal Miller Act, which is 40 USC section 3101 et sec, that governs the recovery on payment bonds on federal projects, and Arizona's Little Miller Act, which is derived heavily and based on the Federal Miller Act, governs payment bond claims for the most part on public projects in Arizona. And whether you are entitled to make a claim on the bond under the Federal Miller Act or Arizona's Little Miller Act depends on the tier of contractor or supplier that you are. And this slide shows the folks that do have bond claims and the folks that do not. The payment bond is going to be posted in most instances, by the general contractor on the project. So those who are in direct contractual privity, whether it be a supplier or a subcontractor, are entitled to make payment bond claims on a project. Those who are in direct privity with a subcontractor of that general contractor, whether it be a supplier or a second-tier subcontractor, are also entitled to make payment bond claims under both the Federal Miller Act and Arizona's Little Miller Act, but they must furnish certain notices. And if you'll think about this, it's the idea behind the preliminary 20-day notice, which I mentioned a little bit earlier, was to put owners on notice of who's on the project and who's expecting to get paid. With the Miller Act bond claims, like I said a second ago, the general contractor is going to be the party who furnishes the bond, and so they're going to know, presumably, the folks who they've entered into contracts with. So the first-tier subcontractor and the first-tier supplier are not required to provide the notices that are required under both federal and state law, and we'll get to those in a minute. But the second-tier subcontractors and suppliers, and when I say second tier, I mean those that are second tier to a first tier subcontractor, are required to furnish certain notices. The third tier subcontractor, the third tier supplier reflected here, or the second tier supplier to a first tier supplier, are not afforded protection under the Little Miller Act and the Federal Miller Act, but they may be afforded protection if a subcontractor is also required to furnish a bond, and they do so. So that's an important consideration to think about in that circumstance. So under the Federal Miller Act, laborers and material men with no direct relationship to the general contractor furnishing the payment bond must give written notice to the contractor within 90 days from the date on which the person did or performed the last of the labor or furnished or supplied the last of material for which the claim is made. So under the Federal Miller Act, there is no preliminary 20-day notice requirement. But if you are in the tier that have to give notice, and those folks being those with no direct relationship to the general contractor, you have to give notice within 90 days of when you last provide materials or furnish labor, and let them know in writing that, hey, we're out here, we haven't been paid, and we are preserving our payment bond claim. Under Arizona's Little Miller Act, the notice requirements are slightly different. As I alluded to at the outset, if you do not have a direct contractual relationship with the general contractor posting the bond under Arizona's Little Miller Act, you are required to serve a preliminary 20-day notice at the outset of work on the project. And then if you are in that situation where you don't have a direct contract with the general contractor furnishing the bond, you're also required to give a 90-day post-completion notice, which states the amount claimed and the party for whom the material was supplied or the labor was performed. Now, a pro tip, I think number 5 here is you have to be patient with your payment bond claims. Under both federal law and Arizona law, you can't sue to collect on a payment bond until you let that 90-day period from when you last furnished labor or materials to a project to expire. Suits before that time will be thrown out as premature. So you have to wait 90 days to see if you get paid, and then once that 90-day period is up, you can go ahead and sue, provided you've provided the requisite notices to recover on your payment bond claims. Now, the statute of limitations for filing suit under Arizona law or federal law to recover on a payment bond claim is a year after the date that the claimant last performed labor or supplied material to the project. And pro tip number 6 here is to note the difference between this deadline and the deadline to sue to foreclose on mechanics liens. And when I say that, I mean the deadline to record and then sue to foreclose on mechanics liens. The deadline to record a mechanics lien can be from 60 to 100 days and 80 days, depending on the circumstance. It's 120 days after completion, but that can, and if notice of completion is served, that will truncate that timeline. But it can be anywhere from those 60 days to up to 180 days after work physically stops on a project, depending on the circumstance. And that is when all work stops on a project. With respect to payment bonds, it's different. It's when you last furnish labor or materials to the project. So if you're supplying work to a project where a Federal Miller Act bond is in play or a Little Miller Act bond is in play, it's important to know and calendar when you last furnished labor or materials to the project, and know that you have a year from that date to go ahead and sue to recover on your bond claim. And that's it in terms of what I have to cover today with respect to preliminary 20-day notices, lien claims, and bond claims. Obviously, this is it's one of the most technical areas of law that you'll deal with. There is a lot of things to be wary of, traps for the unwary, pitfalls that you can fall into, and so you need to proceed with caution in circumstances where you have lien and bond claims. But the most important step early on, like I said at the outset, separate and apart from entering into a solid contract, is to make sure you serve an adequate preliminary 20-day notice as soon as you can, and preferably within the first 20 days of working on a project. So that concludes what I have to talk about today, and I'm happy to take any questions that anyone may have. And
wonderful. Thank you very much, Kevin, and for all of the attendees on this webinar. If you look on your right side, there's an area where you can ask specific questions. If you'd be so kind as to leave specific companies' names out, that would be very helpful. We're gonna skip these slides today, just information about SunRay's application. So if we go to the very end of our presentation, I'm not sure, maybe you can go, Kevin, all the way to the very end and share your last slides with everyone. Yeah, that one right there, the questions, 29, on 29. Or the very first one, perfect. Here's,
I'm sorry, I will get
no,
there.
don't worry about it. The first one or the last one has our contact information. So if anyone has a specific question that pertains to the preliminary notices, such as, I know there one was a recent question, do you notice multiple projects? Pardon me, do you send out multiple preliminary notices for a specific project if it's a leasehold interest? So if you have a kind of a quirky question that wasn't addressed, please feel free again to ask those questions, or if you come up with a question that you didn't remember, feel free to send us an email or contact us, and you could see our information below. But so far, I think, Kevin, you probably gave so much information that everyone's probably thinking, oh my goodness, maybe I have more questions, but I'll ask later. Well,
yeah, and if someone has a question later, please feel free to give me a call. I'll be happy to chat with them.
Okay, wonderful. Well, Kevin, you did a very nice job. Thank you very much for your time, and to everyone else that attended our webinar, thank you, and I hope you have a sunny day.
Thank you, Ariella.
Thank you.